about Articles 3 and 4 of the Constitution. Article 3 goes over the judicial branch, or in other words, the federal court system. Article 4 goes over the relations between states. The judicial branch's job is to interpret laws, or in other words, determine if a law has been broken. The only court named in the Constitution is the Supreme Court, so in other words, when the country was founded, it was the only court. However, Article 3 states, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish." This means that Congress has the power to create other federal courts below the Supreme Court, and they have done so. Today, there are many federal courts spread out across the country. Article 3 also discusses the jurisdiction of the federal courts. Jurisdiction means the right to hear a case. The federal courts can hear any cases that involve the Constitution, federal laws, ambassadors, disputes between two or more states, and disputes with foreign countries. If a case does not fall under one of these categories, then the federal courts do not have jurisdiction. That usually means the case must be heard in a state court instead. The Supreme Court usually only hears cases that have already been tried in the lower federal courts and are being appealed. An appellate or appeals case is a case where a lower court has already tried a case, but a person involved in the case disagrees with the verdict and wants it reversed or changed. Most of the cases that come before the Supreme Court are considered appellate cases. However, there are two types of cases that are viewed as so important that they are heard directly by the Supreme Court without going to a lower court first. These cases include ones involving ambassadors and cases in which a state is a party. Therefore, the Supreme Court has two types of jurisdiction. Appellate jurisdiction, when they hear a case on an appeal from a lower court, and original jurisdiction, when they have the right to hear a case for the first time, but remember, only ones involving ambassadors and states. Now we will move on to Article 4. Article 4 goes over the relations between states, or in other words, how states are expected to interact with one another. Section 1 of Article 4 is known as the Full Faith and Credit Clause. It says that all states must respect the laws, public records, and court decisions of the other states. Section 2 is known as the Privileges and Immunities Clause. It says that each state must give residents of other states the same rights and privileges it gives its own residents. Section 2 also deals with extradition. This means if you commit a crime in one state and flee to another state, that state should send you back, or in other words, extradite you to the state where you committed the crime. You will then stand trial in the state where you committed the crime originally. Section 2 also states that no new state may be created or admitted to the Union without the permission of Congress. Lastly, all states must have a republican form of government, in other words, a democracy. Under these terms, all states are guaranteed protection if they ask the federal government for help. Let's review. Article 3 outlines the judicial branch. This includes the Supreme Court, the lower courts, and their jurisdictions. Article 4 outlines the relations between states, including the Full Faith and Credit Clause, the Privileges and Immunities Clause, extradition, procedures for the admission of new states, the requirement that all states must be democracies, and the idea that all states are entitled to the protection of the federal government if they ask for it.